Greetings and welcome to Law of Evidence, Burdens of Production. Oh, wait, we got the wrong thumbnail here. Pardon me 1 second. How'd that happen? Yeah, all right, there we go. Welcome to Law of Evidence, Beyond Reasonable Doubt from American Jurisprudence. We gotta change that. It didn't change there either, huh? There we go. Beyond Reasonable Doubt from American Jurisprudence. Well, since no one came in yet, I guess that's okay. We could just start right from here. Greetings and welcome. We're going to get right down to the subject, which is going to be in criminal cases. We've been covering judicial notice in a lot of different areas. We moved on to the last one we just looked at there, and we're now on to the criminal cases and the reasonable doubt standard and beyond. So let's get right down to it. All right, Liberty Absurdity, got the notification. Greetings and welcome. Let's get right down to it here. Beyond reasonable doubt standard, generally. Section 168. As a matter of due process, the prosecution must prove beyond a reasonable doubt every fact necessary to constitute the crime with which the defendant is charged. Thus, a state may not specify a lesser burden of proof for an element of a crime. So, as they're saying here, every fact necessary to constitute the crime. So, the state may not specify a lesser burden for proof for an element of a crime, nor may a state specify a fact as an element of a crime and then impose upon the defendant the burden of disproving it. The burden to prove the elements of the crime beyond a reasonable doubt never shifts. It remains on the prosecutor throughout the entire trial. So, the burden to prove the elements of the crime beyond a reasonable doubt never shifts. It always remains on the prosecutor throughout the entire trial. And that comes from footnote 62. And let's see which one that is here. State versus Stump in Iowa. State versus, all right, so we have a few holdings here. We have an overview supplement. Now, just to remind everyone, this is not to be used for anything in, beyond the YouTube broadcast purposes for this channel. Not to be used, construed, or misused for anything legal, lawful, personal, private, business, tax, financial, or otherwise. So please don't do this at home. Let's proceed. So we are reading from the 1998 edition of American Jurisprudence, and with it will be the supplement. So the text itself is from predating 1998, and these supplements will be closer to that. So we have here like a 1993 holding. Nonetheless, since the subject is law of evidence, very little changes, especially within decades, but there are some situations where, of course, this is just to get a general overlook of the law of evidence, that newer holdings may apply. So the case authorities here on this supplement overview. On appeal to Court of Appeals, proper standard of review in case where evidence against accused is wholly circumstantial is whether evidence before jury was legally sufficient to support finding of guilt beyond reasonable doubt, even though people, capital P, people, are obliged to prove accused guilt to a moral certainty, and defendant is entitled to jury instruction in words or substance to that effect. Phrase, proof to a moral certainty, those are some heavy words, is simply description of standard to be applied by fact finder in cases of purely circumstantial evidence. Purely circumstantial evidence has to have a proof to a moral certainty. Wow, that's the standard applied by fact finder. Interesting there. People versus Wong. There's your capital P. All right. Let's see here. The prosecution must prove all the elements of a criminal offense beyond a reasonable doubt. The prosecution's burden is not relieved by a defendant's tactical decision not to contest an essential element of an offense. So here's where we get the entirety of it. And here we have some forms, the instructions of burdens of proof on prosecution from our pleading and practice forms of American jurisprudence. We also have criminal procedure form 357, which is, they got in that addition there. Instruction, burden of proof may be met by circumstantial evidence. Interesting. And a statute making non-support of one's child a crime and requiring the state to prove non-support beyond a reasonable doubt, but to prove that the defendant is the child's parent by only a preponderance of the evidence violates the due process clause of the 14th Amendment. Oh, gosh. That's an interesting one there. Preponderance. That the defendant is the child's parent. Okay. Statute providing that if the prosecutor proved beyond a reasonable doubt that the defendant committed an unlawful intentional killing, malice aforethought was to be conclusively implied unless the defendant proved, by a fair preponderance of the evidence, that he acted in the heat of passion, on sudden provocation, held unconstitutional. Wow. So a statute that if a prosecutor proved beyond reasonable doubt that the defendant committed an unlawful intentional killing, malice aforethought was to be conclusively implied. That means that the jury considers it a conclusive fact here, implied, unless the defendant proved by a fair preponderance of evidence that he acted in the heat of passion. Wow. On sudden provocation. But that held unconstitutional. See, was to be conclusively implied unless. Oh, okay. So that was held unconstitutional. So I wonder what the details of that was. But again, I think this even comes into a point of, let's see, this is footnote 61. It's kind of hard finding these footnotes on this one here. Here we go. Nor may a state specify a fact as an element of a crime and then impose upon the defendant the burden of disproving it. So that's what they're talking about. Just making sure here. So the nice thing about American jurisprudence is it does give you a multifaceted view of these, so that as we dig deep in to try to understand the context of this case here, that it was made clear earlier. And here we see how, that actual, what we would call it here, well, this overview here about the use of the reasonable doubt standard, as it applies to the defendant having to disprove. So that burden cannot be put on a defendant. This is the case here. Criticized on other grounds, but it might be this Mullaney versus Wilbur is what they're referring to in this one here, it appears. And as to the validity of presumptions in a criminal case, see section 191, which, not sure we'll be on that section with this section tonight. All right, we're on to section 169. Before we do that, let's check over the chat and see if anyone's made it into the room yet, because I know the notifications were a bit thin. All right, Facetious Expert did get the notification too. Great. So it just might be coming in, trickling in a little slow tonight, but I'm glad it's getting out there. Let us proceed. So let's see here. Section 169, defined as important life decision. The important life decision definition of beyond a reasonable doubt. Defining beyond a reasonable doubt as the kind of doubt which folks in the more serious and important affairs of their own lives might be willing to act upon, is one approved definition. I like that one. So the important life decision definition of beyond a reasonable doubt, defining beyond a reasonable doubt as, so reasonable doubt is the kind of doubt which folks in the more serious and important affairs of their own lives might be willing to act upon. Several courts have approved of this explanation of beyond a reasonable doubt, substituting hesitate to act or variations of it for the willing to act phraseology. Attempts to clarify the definition further by citing various examples of major life decisions have not generally been successful. Wow, major life decisions. So beware, that's probably not a good strategy to use here. Let's see, footnote 65. Okay, Commonwealth. See here, stating that an instruction using as examples of major life decisions, whether to continue getting an education or to leave school to get a job, whether to get married or to stay single, or whether to buy a house or continue to rent, tended to trivialize the awesome duty of the jury to determine whether the defendant's guilt was proved beyond reasonable doubt. Wow. That makes sense. Can't argue with that, jurisprudence. So we have on here for Section 169 supplement, defined as important life decision, praxis aids. Nice. Supreme Court's views as to proper definition of reasonable doubt for purposes of requirement under due process clauses of federal constitution's 5th and 14th Amendments to prove criminal defendant's guilt beyond reasonable doubt. Nice. So there's your authorities right there. Supreme Court views as to the proper definition. So we don't need to worry about these other definitions. The Supreme Court's views for purposes of requirement under due process clauses, 5th, 14th Amendments, to prove criminal defendant's guilt beyond reasonable doubt. Some courts have accepted the folksy definition here. What in the affairs, serious and important affairs of their own lives might be willing to act or hesitate to act or willing to act upon. All right. And we have for footnote 64 some other notes here. Compared with the standard one would apply in making important decisions in daily life. Compared with the standard one would apply making important decisions in daily life. Compared to what? 64. Okay, so affairs of their own lives. Oh, in the more serious and important affairs. Okay, as compared with the standard one applying making important decisions in daily life. Hesitate to act language is acceptable. Willing to act language is not. Ah, wow. Another fine distinction in your phraseology here. Definition of beyond a reasonable doubt stated that the term described proof of such a convincing character that you would be willing to rely upon it without hesitation in your most important affairs of your own. That's been criticized. Another definition requires that the proof be so convincing that an ordinary person would be willing to make the most important decisions in his or her own life. Now, I've seen this one here before. We say ordinary person, and we're talking about reasonable doubt. And we did take a nice deep dive on the word reasonable previously. So it's important to really consider that this one right here, that an ordinary person would be willing to make. Now we're seeing that willing phraseology creeping in here, though. Another definition requires that the proof be so convincing that an ordinary person would be willing to make the most important decisions in his or her own life. So, not your daily decisions, the most important decisions. And the willing, this gets to be a little more difficult in this language here, but this is United States versus Jaramillo Suarez, Daily Journal. Okay, we have the Commonwealth versus Ferreira, stating that an instruction using as examples of major life decisions, I know this is the most important decisions in his or her own life, and major life decisions. Whether to continue getting an education or to leave school to get a job, whether to get married or to stay single, or whether to buy a house or to continue to rent, tended to trivialize the awesome duty of the jury to determine whether the defendant's guilt was proved beyond a reasonable doubt. All right, now we're getting on to the moral certainty test, section 170. Let's jump over here. All right, and we have the facetious expert, haha, 69. Let's proceed. In the past, courts often defined beyond a reasonable doubt by equating it to a moral certainty. Moral certainty. Recently, however, the reference to moral certainty rather than evidentiary certainty has been disapproved as creating too great a risk that a reasonable juror might interpret the instruction to allow a finding of guilt based on a degree of proof below that required by the Due Process Clause. And for Section 170, we get the Moral Certainty Test Supplement. Practice aids. Supreme Court's views as to the proper definition of reasonable doubt for purposes of requirement under the Due Process Clause of the Constitution's 5th and 14th Amendments to prove criminal defendants' guilt beyond reasonable doubt. I think we read that in the previous one too. And case authorities. That's one thing about in American jurisprudence, although it may sound redundant to see the same practice aid here as we saw it here. The fact that it's as an important life decision, the same practice aid applies as the moral certainty test. Now we're on to the case authorities. There is no error in a non-capital first-degree murder prosecution where the court gave a moral certainty, reasonable doubt instruction during jury selection, which defendant contended reduced the said state's burden of proof below the standard required by the Due Process Clause. The reasonable doubt instruction given during jury selection, taken as a whole, correctly conveyed the concept of reasonable doubt to the jury. Moreover, even if there was an error in the preliminary instruction, the trial court's use of the pattern jury instruction in its charge to the jury before it retired for deliberation cured any possible defect in the earlier instruction. Wow. So the moral certainty during jury selection, but it can be cured by the instruction in its charge before the jury retires. Interesting. And that's case authority going to 1995. So these are the more recent little shifty plays you see going on in various cases. And that's why we like these supplements here with American Jurisprudence and why it would behoove one if they are litigating any of these kind of matters that you would want to see the most current supplements. That said, let's check over here onto the chat before we go on to section 171. Facetious experts only had a couple whiskeys. Back to business, yeah. Well, like any good esquire, you could have some fine whiskey there if you're going to be doing any kind of legal work. So I will not criticize. Let's proceed. Section 171, jury instructions. Woohoo. Any definition of the term beyond a reasonable doubt must not detract from the heavy burden suggested by the use of the term reasonable doubt standing alone. Wow, beyond a reasonable doubt and the term reasonable doubt. Wow. However, deciding whether an instruction defining beyond a reasonable doubt creates reversible error, the courts must consider how reasonable jurors could have understood the charge as a whole, even if the judge has improperly defined beyond a reasonable doubt. A conviction may nonetheless be affirmed if, taken as a whole, the instructions correctly convey the concept of reasonable doubt to the jury, properly emphasize the gravity of the decision the jury must make, and not detract from the jury's understanding of the extent of the burden. So, if the judge improperly defines it, they may still have a conviction if, taken as a whole, the instructions correctly convey the concept of reasonable doubt. So the judge can kind of slip in his little improper definitions. But as long as the instructions as a whole correctly convey the concept of reasonable doubt to the jury and properly emphasize the gravity of the decision and not detract from their understanding. Boy, they like it easy on themselves, them judges, don't they? Attempts to explain the term reasonable doubt do not usually result in making any clear to the minds of the jury. As a result, no definition of beyond a reasonable doubt is constitutionally required. Wow. Attempts to explain the term reasonable doubt do not usually result in making it any clearer. I wonder if we could do that here. That seems an insult to people's intelligence to make a statement like that. That came from what? Footnote 71? Holland versus United States. Well, I take exception to that statement. And that means that we have to take a quick digression here over to Black's Law Dictionary. We're going to be looking at we've got the 9th edition here, which would be one that no one would complain about in any of the courtrooms today. And we're going to look up this word reasonable once again, because I remember there was a particular edition in here that gave some extraordinary clarity to the term when it's used in its legal context. And I think it would behoove this audience to take a little deeper dive into this word as we keep seeing it repeated over and over again, and with the implied notion that it would confuse us more just to try to get more clarity on the term, which I find to be kind of counterintuitive, if not just flat out wrong. And just bear with me here because this is a scanned version here and it doesn't scroll very easily. And it's not searchable. Okay, so let's see here. We're getting close. It just kind of hangs for a while there. There we go. So we're getting close to reasonable. Here we go. Reasonable. So this is the one I really like here, is because this section here really brings some clarity, I believe, to the term. So let's see here. Reasonable, adjective from the 14th century. So definition 1 is fair, proper, or moderate under the circumstances. And they give an example here is reasonable pay. 2, according to reason. So your argument is reasonable but not convincing. Interesting. So in a logical sense. And now here we get the real clarity. It is extremely difficult to state what lawyers mean when they speak of reasonableness. Now we uncover why it's so unclear. It's because of the way the lawyers state it. So, in part, the expression refers to ordinary, here's our word, ordinary ideas of natural law or natural justice. So reasonableness refers to ordinary ideas of natural law or natural justice, and in part to logical thought, as in definition 2, according to reason, working upon the basis of the rules of law. Now, that seems rather clear to me. Instead of having difficulty in stating it, we could say, in part, the expression, part of it, refers to ordinary ideas of natural law or natural justice, and the other part to logical thought working upon the basis of the rules of law. In one sense, the word reasonable describes the proper use of the reasoning power, and in another, it is no more than a word of assessment. Reasoning does not help much in fixing reasoning does not help much in fixing a reasonable or fair price, or a reasonable or moderate length of time, or in estimating the size of a doubt. Wow. Lawyers say a reasonable doubt, meaning a substantial one. The Court of Appeal has frowned upon the description of a reasonable doubt as one which reasons could be given. Wow. So it has nothing to do with reasonable doubt with a doubt for which reasons could be given. Interesting. So meaning a substantial doubt. So a substantial doubt, you could say, is reasonable doubt in this case here. But anyhow, we have definition 3 of a person having the faculty of reason. A reasonable person would have looked both ways before crossing the street. And 4, we have an archaic definition here, human. Reasonable meaning human, huh? Criminal homicide is traditionally called the unlawful killing of a reasonable person. Wow. That's interesting there, and that's, of course, archaic, so we wouldn't be using that. And that takes us to the end of that digression. And I thank you all for joining on that one. Let's get back to the topic. While we're here, we could also check in with the chat as well. My goodness, I'm glad I was here to hear that. Facetious expert, I'm glad you were here too as well. I think we clarified what American jurisprudence was implying that we couldn't. So what they said here, attempts to explain the term reasonable doubt do not usually, there, we missed the word usually, result, because tonight I think it was one time where it did make it clear to the minds of the audience here, which is our de facto jury. As a result, no definition of beyond a reasonable doubt is constitutionally required. Of course, natural law, natural justice, we don't need any further definition, do we? Some courts discourage judges from defining reasonable doubt, although merely because judges define beyond a reasonable doubt to the jury does not require automatic reversal. As we read, other courts explicitly require that the judge explain beyond a reasonable doubt to the jury. So that's footnote 74, where they have a case where they had to do it. United States versus Delibach, and Friedman versus United States versus Pepe. So it looks like a lot of them here. One definition of beyond a reasonable doubt accepts an instruction that defines reasonable doubt as a doubt based on reason and common sense. But we just read, now of course this is maybe newer. But they're saying one definition of beyond a reasonable doubt accepts as an instruction that defines reasonable doubt as a doubt based on reason and common sense. Reason alone wouldn't be enough. It would have to be common sense and using reason acting upon the rules of law, as we just read. So as you can see here, salute to the audience for being here and taking these deep dives. As you can see, even when it gets to the appellate court, some of them still don't have clarity as to the terminology's meaning, which we seem to have been able to elucidate to some extent tonight. So let's see here. Section 171, the Jury Instruction Supplement, the Practice Aid, Supreme Court views as to proper definition of reasonable doubt for purposes of requirement under due process of the Federal Constitution's 5th and 14th Amendments to prove criminal defendant's guilt beyond reasonable doubt. And we have something in the practice and pleading forms here regarding definition of reasonable doubt. That would be an interesting one to look into. Let's see, it's AmJur. Okay. We're on to section 172, the application of rule on post-trial motion or appeal. This is an important one here because, as we know, a lot of the presumptions sometimes steamroll the initial trials, and post-trial motions are sometimes necessary and less burdensome than an appeal. Let's jump over here to the chat really quick, make sure we're here up to date. We have Magus Galzu. So under their own definition, is a reasonable person is a slave because humans are monsters and cannot own property. A person is defined as an infant. No, not really. Is not the definitions we just saw there. A reasonable person, even the archaic one, is just a human. So when we look at it like that, it's not a slave or a monster in any extent. I'm not too sure where that comes from, but it wouldn't be substantiated anywhere, and it'd be a tough one to bring into a court. All right. Standard for appellate review of a post-conviction motion for judgment of acquittal, notwithstanding the verdict is identical to that employed to measure the sufficiency of the evidence supporting a guilty verdict. So, the standard for the appellate review is for an appellate review of a post-conviction motion for judgment of acquittal, notwithstanding that the verdict is identical to that employed to the measure the sufficiency of the evidence supporting a guilty verdict. So we're looking for a measure of sufficiency. The evidence is sufficient to withstand the defendant's motion or appeal so long as a rational juror could be satisfied that the government has proven each element of the crime beyond a reasonable doubt. In making this assessment, the court is required to view the evidence in the light most favorable to the prosecutor, giving the prosecutor the benefit of all reasonable inferences that could be drawn from the evidence. So, pretty high standard for the appellate review of post-conviction in this context here, and lots of cases here. Let's see, I stated on appeal, the court must look at the evidence in a light most favorable to the prosecution, drawing all legitimate right. That it would only make sense considering that that's how the jury already ruled. So if you're going to re-look at it, you would still look at it saying that the jury give that the benefit of the doubt as the way the jury ruled, so that there would have to be a high standard of evidence for it to be overturned. Criticized on other grounds. Let's see, among conflicting authorities on other grounds. All right, lots of case holdings involving this. As you can see, not much written about it. High standard for appellate review of post-conviction motions. Word to the wise, get it right the first time out. You see how burdensome it can become. Speaking of burdens, on a section, or this is chapter 2, burden as to particular allegations or elements. And section 173, place of commission of crime, the venue. Since the criminality of an act depends not only on its perpetration, but that it be in violation of the penal laws of the state where it committed. The place of the act may be an ingredient of the crime which must be proven by the prosecution. However, the view that venue is not an element of a crime and therefore need not be proven beyond a reasonable doubt appears to be followed by federal courts and numerous state courts. Interesting. So it's not even an element. A number of state courts, however, have held that the prosecution must indeed prove venue beyond a reasonable doubt. Footnote 81. Wow, a lot of hate holdings on this one. Oh my gosh. All right, so well deliberated and debilitated. Whew. So venue. And I know this is always a contentious issue here in the courts. We have a supplement for venue. Great. Section 173, place of commission of crime, venue supplement, case authorities. When jurisdiction in a criminal prosecution is challenged, the state is required to prove beyond reason. Okay, this is just these are kind of just abridged here. When jurisdiction in a criminal prosecution is challenged, the state is required to prove beyond a reasonable doubt that the crime with which defendant is charged occurred in North Carolina. That's State v. Rick, 1995. The evidence in a second-degree murder prosecution made a prima facie showing of jurisdiction sufficient to carry the case to the jury and permit the jury to infer that the murder took place in this state, although the victim's body was found in a stream in South Carolina, where it tended to show that shortly after leaving work at 11 p.m., the victim went to her home in Mount Holly, 2 doors from where the defendant lived, and changed from her work clothes into a dress. A few hours later, the defendant was seen in the vicinity alone, driving the victim's car. A breaking and entering occurred at the victim's home. Acts of violence took place in the home as reflected by broken glass, dishes on the floor, in the bedroom in disarray, a cement block and a rock used by the killer to sink the victim. Body in the stream some 14 miles away were taken from the victim's yard on the morning following the killing. Defendant left on his former sister-in-law's car a Bible in which he had written that he was going to. That afternoon, the defendant told a friend that he had done something for which the police were going to not like him. And when the defendant was arrested, he told the police that the warrant would be worthless if he could prove he did that to that woman in South Carolina. Man, when jurisdiction is challenged, oh my gosh, when jurisdiction is challenged, and the trial court makes a preliminary determination that sufficient evidence exists upon which the jury could conclude beyond a reasonable doubt that the murder occurred in South Carolina, the trial court must instruct the jury that unless the state has satisfied it beyond a reasonable doubt that the murder occurred in North Carolina, it should return a verdict of not guilty and a special verdict indicating a lack of jurisdiction. Wow. In this prosecution, in which the defendant challenged the facts of jurisdiction, the trial court erred by failing to instruct the jury that the state bore the burden of proving jurisdiction, in that if the jury was unconvinced beyond a reasonable doubt that the essential elements of the crime occurred in North Carolina, it should return a special verdict, so indicating. Wow. That was pretty heavy there. Yikes. While the burden of proving that the crime occurred in the district is on the prosecution is not required to meet the reasonable doubt standard applicable to the substantive elements of the offense. Rather, the prosecution need only show by a preponderance of evidence that the trial is in the same district as the offense. Wow. All right, now we're on to section 174, the corpus delicti. U.S. Code 1. Yeah, I mean, if you're under U.S. Code, most of the cases we're talking about here aren't. And this is all the criminal stuff here anyway, so. The corpus delicti must be established by the prosecution, meaning that the prosecution must establish the actual commission by someone of the particular offense. There's your corpus delicti, body of the crime, observation, the proof that the defendant committed the crime is also necessary for a conviction, but it is not an element of the corpus delicti. Wow. So proof the defendant committed the crime is not an element of the corpus delicti. Interesting. That's from Wharton's Criminal Evidence, 14th edition, section 17, required reading for anyone that wants to know more about criminal evidence. And that said, let's move over here to the mental state, section 175. Where mental state is an element of the crime, the prosecutor must prove it beyond a reasonable doubt. This is where we could get over to our judicial notice, too. But if intent is not a necessary element of a crime, it is not essential for the prosecution to affirmatively prove the purpose for which an alleged crime act was performed. If intent is not a necessary element of the crime. I thought intent made the crime. Interesting one there. Footnote 85. What could that be? People versus Wells. Although a state may require a defendant to prove an affirmative defense, such as self-defense, some of whose facts tend to negate the mens rea of element of the crime, the state may not place upon the defendant the burden of disproving the mental state specified in the definition of the crime. Oh, so they say someone's crazy, they don't have to disprove it. If intent is a crucial element of the crime, the state must prove it beyond a reasonable doubt, of course, because all elements have to be held to that same standard, beyond reasonable doubt. And any instruction which effectively shifts the burden of proof to the defendant is impermissible. Thus, for example, in homicide cases, a state is constitutionally required to disprove the defense of accident, because accident is no more than the negative of intent or malice. Wow. Now that's an interesting one there. A state is constitutionally required to disprove the defense of accident, because accident is no more than the negative of intent or malice. Footnote 89. Oh boy, lots of cases here. Wow. Okay, we have some notes on it though. Under the rule that the prosecution's burden is not relieved by a defendant's tactical decision not to contest an essential element of an offense, evidence of a child's injuries used to establish battered child syndrome was relevant to show intent, and the state was not required to refrain from introducing such evidence, even though the defendant did not raise the defense of accidental death. Jeez. Burden of proof on defense that killing was accidental. So the burden is not relieved by the defendant's tactical decision not to contest it. So the state had a constitutional obligation. The state was not required to refrain from introducing. Oh, okay. government did not raise the defense of accidental death. Interesting there. So they were still able to bring in that evidence. God, I didn't want to think about those cases. Those seem pretty awful. Some of these cases could be worse than a crime drama script. All right, let's see here. I guess that's it for this section here. We had 168. We did all these mental state. Discussion of burden of proof with regard to affirmative defenses. I think we're coming up on that. If I'm not mistaken. Yep, it's coming up soon. Let's read the one about the heroin case. In a heroin prosecution, an instruction cannot shift to the defendant the burden of proving that the defendant had no knowledge that the substance involved was heroin. That's a good one. All right, we're on to section 176, the negative allegations, exceptions, and the like. And let's jump over here to the chat and see if we have any other comments here. Looks like we're up to date, so let's proceed. What a negative averment. Remember, an averment is a statement of fact, is an essential element of a crime. Negative averment. Negative averment is an essential element of a crime. The burden is still generally on the prosecution to prove the elements of the crime. However, the burden may be placed on a defendant where the negative of the issue is not susceptible of direct proof. Of the facts are more immediately within the accused's knowledge, such as where the circumstances could be readily disproved by the production of documents or other evidence within the defendant's possession or control. For instance, let's see this. While there are cases holding that in a prosecution for carrying a weapon without a license, lack of a license is an essential element of the crime that must be proved by the prosecution. The general rule followed elsewhere is that the burden of proof as to whether the defendant was licensed is on the defendant. Similarly, where the language of such a statute is construed as creating an exception for those who have permits rather than an element of a crime, the prosecution does not have the burden of proving a lack of permit. However, in such a case, it is error to require that the defendant prove that the exception applies by a fair preponderance of the evidence. Instead, the defendant may be required to go forward with sufficient evidence to establish a prima facie case of the issuance of a permit, and the prosecution would then have to disprove that evidence beyond a reasonable doubt. So, if you could get just a fair preponderance of evidence saying you have a permit, now the burden is shifted. The prosecution would have to prove that beyond a reasonable doubt. However, I think this whole thing about permits for Second Amendment rights is kind of nonsense, but I digress. Footnote 95, Minnesota. All right, we're on the supplement for section 176, negative allegations, exceptions, and the like, case authorities. The trial court's admission of an SBI agent's testimony in response to a question by the prosecutor that neither defendant nor his attorney had given the shoes worn by defendant on the night of the crime to law officers for comparison with shoe prints at the crime scene did not improperly allow the state to shift the burden of proof to the defendant in violation of his rights to due process, but merely allowed the witness to inform the jury of the defendant's failure to support his theory of the case. The witness to inform the jury of the defendant's failure to support his theory of the case. Interesting there. All right, so we have on our footnotes here. Annotation. Burden of proof as to lack of license in criminal prosecution for carrying or possession of a weapon without a license. American Law Review, there's some stuff there. And now we're on, speaking of statutes, we're on to statutes of limitations, section 177. And let me refresh this chat here. I have a feeling it's not refreshing. There we go. Okay, we're all good. If you just joined in, please hit the like. Make sure we get the word out. Although notifications did go out, it seemed they were rather thin. Let's proceed. Since statutes of limitations create a bar to prosecution, the prosecution must affirmatively prove the commission of the offense within the period limited by the statute. If the prosecution relies on an exception, it has the burden to show its right to prosecute. All right, now we're on to section 178. There's a good one here. Affirmative defenses. As to certain defenses, various jurisdictions assign one or more of the burdens to the defense. For example, the view is split whether the burden of proof on the issue of insanity is on the prosecution or defense. Furthermore, there is no constitutional barrier to requiring a defendant to produce sufficient evidence of certain defenses before the prosecutor is obliged to rebut or overcome such defenses. Constitutional questions arise, however, when the law imposes upon the defendant the burden of persuasion as to a defense. The burden of persuasion, as we were examining in the previous episode. A state may require a defendant to prove a defense by a preponderance of evidence or by a greater burden, so long as the statute contains no presumptions. No presumptions. And does not require the defendant to disprove any fact specified by the statute as an element of the crime. Wow. That's footnote 4. What could that be? Patterson versus New York. Assuming the prosecutor proved the elements of aggravated beyond a reasonable doubt, the defendant was entitled to be acquitted on the grounds of self-defense only if she proved by a preponderance of evidence that, okay, here's our self-defense defense, that she was not at fault in creating the situation giving rise to the argument. Of course, number one, you can't be the one that started the situation and claim self-defense, so she was not at fault in creating the situation. Good. 2, that she acted in the honest belief that she was in imminent danger of death or other great bodily harm. Important phrases there. And that her only means of escape from such danger was the use of deadly force. And 3, that she violated no duty to retreat to avoid danger. Wow. Good stuff there. Absolutely. Okay, so that was footnote 4. Let's get back to where we were here. There are constitutional limits in reassigning elements and burdens of persuasion beyond which the states may not go, and it would violate the proportionality component of the prohibition of cruel and unusual punishment if a state sought, with regard to any felony, to eliminate the mental culpability element and make the absence of such culpability an affirmative defense. Wow. The proportionality component of the prohibition of cruel and unusual punishment to eliminate mental culpability element, make the absence of such culpability an affirmative defense. Wow. Footnote 6. It's Morissette versus United States. Law making a felony to unlawfully take the property of another, unless the defendant proved by a preponderance of the evidence that he reasonably believed the property to be his own. Ha ha. Interesting one there too. And as to whether states may constitutionally place the burden of proving insanity on the defendant, See criminal law, section 77. Wow, that's a good one there. All right, let's get on to the supplement here. Section 178, Affirmative Defenses Supplement. Here's our case authority. The trial court in a first-degree sentencing hearing did not err when instructing, hey, we saw this before, the jury on the defendant's burden of proof by defining preponderance of evidence as the evidence, this is different, which must satisfy you rather than as more likely than not. Wow, so this is good. The first-degree sentencing hearing did not err when instructing the jury on the defendant's burden of proof by defining preponderance as evidence which must satisfy you. So that was okay to tell the jury that, rather than more likely than not. Huh. That is odd. All right, in our footnotes here then, it was constitutional to place the burden of production on the defendant as to the defenses of duress and necessity. Pay attention. And to direct that if the defendant fails to satisfy that burden, he is not entitled to a jury instruction on the defense. It was the burden of production. Well, as duress and necessity. So there, defense making those claims, then I guess you have the burden of production. The amount of proof required to put the prosecution to its proof as to the issue of sanity is discussed in criminal laws, section 76. Let's see here. This one here, upholding a homicide statute which defined as any intentional, unlawful killing, but providing, however, that it could be mitigated to manslaughter if a defendant proved by a preponderance of evidence the affirmative defense that the killing occurred while the defendant was under the influence of extreme emotional disturbance for which there is a reasonable explanation or excuse. Really? That sounds nice. So I guess that's like a temporary insanity? Because they're extreme emotional disturbance for which there was a reasonable explanation or excuse. Man, I don't know about that one. Assuming the prosecutor proved the elements of aggravated beyond a reasonable doubt, the defendant was entitled to be acquitted on the grounds of self-defense. So we saw this one. All right. And we're on to section 179, alibi. Seems like I'm losing everyone here, but we're almost done. So those that are still here, salute to you. Let's get through this. Although an alibi is sometimes classified as an affirmative defense, it is simply a denial that the accused committed the crime. Thus, proof of an alibi is simply a means of controverting the state's effort to establish a criminal act. The prosecution has the burden to establish that the accused was present at the place and time of the offense. The jury is properly instructed that the defendant has no burden of proof with respect to his alibi, but that the state must disprove the alibi beyond a reasonable doubt. The statutes or rules that require that the defendant give notice to the prosecution of the accused's intent to rely on alibi do not shift the burden of proof. So I guess you can say you're with your mom. Some courts that classify alibi as an affirmative defense only place on the defendant the burden to go forward with evidence so as to raise a reasonable doubt as to his presence at the scene of the alleged crime. But then the prosecution must prove beyond a reasonable doubt the defendant's actual presence there. A state cannot require a defendant to prove an alibi defense by a preponderance of the evidence, because to do so would relieve the state of the burden of proving beyond a reasonable doubt that the defendant committed the act which constitutes the crime. Wow. State cannot require the defendant to prove the alibi defense by a preponderance of the evidence, because it would relieve the state of the burden of proving beyond a reasonable doubt that the defendant committed the act which constitutes the crime. Footnote 14, Johnson versus Bennett in Iowa. Good one. Oh boy, Section 180, prior convictions. When a prior conviction is included in a charge for the purpose of enhancing the punishment, such as under a persistent felon statute, the prosecutor has the burden of proving beyond a reasonable doubt that there was a prior conviction, and that the present defendant was in fact the defendant in the prior proceeding. They have the burden of proving beyond a reasonable doubt. A procedure under which the prosecutor must prove the fact of the prior conviction. A defendant who wishes to challenge the conviction must come forward with some evidence suggesting that the conviction was invalid, and that the burden is then placed on the prosecutor to prove that the prior conviction is valid, is not violative of the right to due process. And here's our supplement on that. The case authority, evidence of counterfeiting, defendant's prior counterfeiting conspiracy, and wait a second. Evidence of counterfeiting, defendant's prior counterfeiting conspiracy, and conviction with co-defendant was properly admitted as probative on issues of intent, knowledge, and plan. Jeez. District Court did not err in not having issued limiting instructions sua sponte, after defense prior convictions for robbery and possession with intent to distribute heroin were introduced into evidence, since convictions introduced by the defendant as part of the defense strategy. Huh, interesting. Okay, this brings us to the end of tonight's presentation. We'll continue next time with Chapter 4, Presumptions. So this is going to be a great area to delve into here. So far with a lot of evidence, we've been going over civil elements, criminal elements, judicial notice, reasonableness, persuasion, and now beyond reasonable doubt. And the next one up is going to be presumptions. So this should be an exciting one. We'll be getting on to that one on the next one of the law of evidence. Now let's get over here to the chat once again and see if anyone is still here. Audit Thems didn't get the notification, but some people say they did. And I tend to believe they did because hardly anyone was in here, so I think the only way anyone could have known was if they got one of the thin, dwindling notifications that are out there, but hopefully next time we'll get them out there. This has been a great one here, and it's been quite long too, but I appreciate everyone that did make it out. Salute to all of you for caring about preserving, conserving our tradition of American jurisprudence by learning it more deeply. Not just the terminology and the practice that's gone on, but the true foundational elements of it that make it really work. And also to be aware of where the rubber meets the road and how we can bring these more into the benefit of the people and not just in the realm of various institutions that aren't really there to forward our hopes of freedom and liberty in this nation to persist for future generations. So with that said, salute to you all for carrying on the tradition for posterity, and we'll see you all on the next one. Peace out.